Good evening, everybody. We are deeply honored to have Mr. Paul Sills, a full-time arbitrator of Arbitra International, with us here today to speak to us on the topic of arbitrating distributed ledger technology dispute. What do we do with crypto and smart contracts? Let me introduce myself first. My name is Simon Wong. I'm a council member of the Hong Kong Institute of Arbitrators, Hong Kong IR. Today's webinar is organized by Hong Kong IR. I'm the moderator of this webinar. As for Paul, Paul is a barrister with 26 years of conflict resolution experience, which followed a successful career as a navigator in the Royal New Zealand Air Force. Paul is an independent mediator and arbitrator now based in London, working with Arbitra International. He is also an active business advisor and independent director, working across a number of industries, including international freight, infrastructure, construction, marine, healthcare, industrial design, retail, leadership, and technology. Paul spent 2 years as the CEO of an international superyacht construction business. Paul has a lot of conflict resolution appointments. He is admitted to practice as a barrister in New Zealand. He is also a fellow and distinguished fellow of many institutes, societies, and centers of arbitrators and mediators. In this year, 2021, Paul was nominated as one of the top 25 most influential lawyers in New Zealand and was in October this year awarded a Lexology Client Care Leadership Award on mediation. Paul regularly sits as arbitrator, mediator, and adjudicator. During this presentation, may I remind the participants to type their questions in the Q&A box. Don't type the questions in the chat box. Type it in the Q&A box. We will answer the questions afterwards. May I also remind the participants to send back the CPD evaluation form to us after this webinar. So now, please join us in welcoming Paul. Paul, the floor is yours.
Thank you, Simon, and thank you to the Hong Kong Institute for this opportunity to talk. And welcome everybody from wherever you are. I understand we have a few jurisdictions here this evening or today, which is great, as this is really a conversation about where we see these issues of disputes for smart contracts, cryptocurrencies, and that space that a lot of us have dreaded getting involved in because of the seeming complexities around the adaptation of technologies. So this is going to be a bit of a whirlwind tour through some areas of concern around the world and bringing them back as and where I can to arbitration and how arbitration in particular might address some of these issues. And we've got a couple of examples later in the paper on arbitrations that are currently underway. We understand dealing in particular with some cryptocurrency asset issues. But this, I wanted to start with this. This is not a new issue. I was on the New Zealand Law Society Technology Committee in the early 90s and remember distinctly discussing things like online courts, virtual hearings, smart contracts, virtual handshakes between business people around the world without having left their own office in the early 90s, at a time where technology was very much in its sort of ab initio, its early stages of looking at these issues. So the concepts that we're looking at now aren't new, and that's I make that point because it's an important point to remember when we are looking at these concerns of how does the law respond to smart contracts, how does it respond to online currencies, because of course the law in many respects has been here before. We've been here with facsimiles before my time, but during my time in practice, the introduction of email and how we would deal with email and online property transactions and stuff. So there is some comfort and some historical backdrop to the law adapting to technologies, and I'll touch upon that more as I get to some concluding comments. But where we start with smart contracts, and we're going to talk a lot about smart contracts, and crypto will come into that as we go through. But Nick Szabo, an American writer and cryptographer, defined it, as you see on the screen, as early as '94. And very importantly, he talked about the fact that the consequences of smart contract design and contract drafting hadn't been explored. And really, you might say, well, we haven't really explored that until in the last 2 or 3 years, where it's gained a lot more traction. And it's gained a lot more traction really since 2009, when Bitcoin came in. But examples that we are all familiar with: electronic data exchange, FPOS transactions, all primitive forerunners to smart contracts. Also worth noting, Mr. Szabo signaled, as I say there, the possibility of synthetic assets. And of course, we've known all about synthetic assets and derivatives and derivative trading since particularly the GFC a few years ago. So very much ahead of his time. But as I said, we were talking about these things in the early 90s. Technology is now caught up and is continuing to expand the possibilities of where these smart contracts might go. And of course, our big concern is, well, how do we take the law along with us? So early example, and we see them still everywhere, vending machines. A vending machine is the perfect example, and they've been around for a very long time, of a smart contract. Everything that you do other than put your money in and make your selection is an electronic if-then sequence of decision making within that machine. And if you haven't received what you selected from your vending machine, you would certainly be very quick to say, I had a contract and I am entitled to receive my M&Ms or whatever your selection of choice might be. A difference that's come in recently and more prominently is this idea of smart contracts that are completely code-based, so only appear in code, never appear more in the form of a traditional legal contract. And we also typically these days focus upon or assume that smart contracts utilize blockchain technology, which we're going to touch upon in a second, but that need not be the case. And of course, the vending machine is an example again of that. But throughout this presentation, we will be talking a lot about what's happening on blockchain technology, and in particular how it is being used or could be used in the assistance of disputes around this type of technology. So as I said, two types of contracts being talked about, and this distinction is still important around the world. The first is the smart contract code, where everything is done and verified and executed electronically. So there's no hard copy, there's no integration between traditional contract and smart contract. And one of the questions, one of the challenges around the world is that type of contract actually, can it be deemed to be a traditional legal contract with all the rights and remedies that are available when you are dealing with a traditional contract? Or is it simply a code execution on a computer that is an agreement between the parties, but not necessarily goes all the way through to a traditional contract? We'll talk more about that in a minute. And then the other ones which we're a bit more comfortable with and which have been around for longer, which are smart legal contracts. That is where smart coding technology is used as a complement to or in substitution for parts of a written legal agreement. And examples of that are where execution or payment it goes online, or I'll take a New Zealand example, even though I'm now in London, where all residential property transactions are bought and sold on through electronic interface. So there's no hard copy documents necessarily anymore in relation to that traditional sale and purchase agreement. So those are the two areas that we are looking at. And I wanted to spend some time in a few slides, and these will all be available to you later, dealing with some of the definitions and concepts. I'm suspecting that because you are on this webinar, you might be scratching your head a little about, well, I hear these terms, where do they fit? What do they mean? And why is that important? And I think it's a fundamental importance to get clear in our heads what this terminology means, how these pieces of technology fit together, because that is a part of understanding the adaptation of them to dispute resolution techniques, such as, in this instance, we're talking about arbitration. So let's start with the blockchain, the thing that we hear a lot about. You might have seen some diagrams, you might have read some of these definitions. So forgive me if this is old hat to you. But a blockchain is what is called a decentralized ledger. So the DLT, the decentralized ledger technology, it is like simply taking a double entry accounting ledger of old handwritten and applying it across the internet on a peer-to-peer network. That means it goes from computer to computer around the world. Whoever wants to log on or is able to log on to that decentralized ledger. It doesn't have a central repository like a central bank or a government archive. It is peer-to-peer, which means it is a network-based ledger recording transactions. And a blockchain, the block is simply a block of information that records the transaction. And we are seeing it being used for fund transfers, for settling trades, for voting, and we're seeing it for trading. And we'll look at that later on in terms of some of the actual arbitration work that's going on at the moment. There's the definition there of a smart contract. That's a really useful one, and it captures both types of contract, enforceable by legal rights, or this idea of a tamper-proof automated execution, which we will touch on shortly. And then cryptocurrencies, or digital or virtual currencies, what are they? And there again, I've said that they work typically these days by being a part of the decentralized ledger. So a currency like Bitcoin or Ether from Ethereum or Dogecoin, as in some of these you will be familiar with, they are themselves a blockchain technology. So that Bitcoin is a blockchain, and it sits on this decentralized ledger like many other blockchains, like the recording of a smart contract on this decentralized ledger is itself a blockchain. So the blockchain is the building block, if you like, for doing these smart transactions. And there are a variety of smart transactions. Cryptocurrencies are an example. Smart contracts are another example that sit on this DLT. So as I say on the next page, and this is more for your reference later on, that decentralized network is made up of a system of computers. They're called nodes. Every single node holds everything. And that's a hugely important function for the authenticity, the immutability of transactions that we see appearing on decentralized peer-to-peer networks, because I can't change it on my computer and put that change out as an individual change without it being sanitized, checked, and accepted by all the other nodes on the network. And that's a very important part of the pluses and the issues for smart contracts when we look at disputes. And as I say there, blockchain is simply a recording of the information, and then I talk more about digital currencies. And again, like smart contracts, they're not new. Digital currency has existed for decades. Most of digital currency is actually held by the centralized banks. The cash that's in your savings account, the money that you use on your credit card, that's not paper money anymore, that's digital currency. So the vast bulk of digital currency is centralized. And what we're really talking about when we're talking about Bitcoins and Ether and other cryptocurrencies is the fact that they are decentralized, that they aren't part of this centralized government-controlled digital money flow. And of course, that's why Bitcoin was invented and put into the marketplace, was to decentralize and take advantage of this blockchain technology. So again, just wrapping those up there, we're not going to go through them, but that's just a wrap up of how those threads come together. So when you hear blockchain, it's the recording system. When you hear smart contract, that's something that's recorded on the system, just as a digital currency is recorded on the system. The system happens to be distributed around the world, peer-to-peer, with no centralized control. So let's have a look at some smart contract examples very briefly. And these are one that AXA set up, which was on travel insurance. And both of these examples, the insurance examples, are parametric, which means they don't pay out on an actual loss. They pay out a predetermined amount on a predetermined trigger. So these are if-then calculations or computations or movements within the smart contract that says, if my flight is delayed by 2 hours, then I get paid $100, and that payment is direct into my bank account. There's no loss adjusters involved. There's no argument about that process. Interestingly, discontinued by AXA, it didn't meet its commercial targets, which I normally interpret as insufficient uptake from the market. One that is used a lot, though, and again, it's another parametric insurance policies and crop insurance. Again, these are predefined payments on predefined circumstances, typically for crop insurance in and around temperature, on things like orange groves, which are very susceptible to temperature. And if you get some temperature spikes, particularly cold spikes, then you are changing from selling an orange to selling orange juice, and that's a very different price point. So again, a smart contract, all online. One of the things that will come up shortly when we talk about it is that temperature, that flight information has to come from somewhere. So how does that factor into smart contracts? And then blockchain property registers, which we are starting to see quite a bit about. So these smart contracts, are they perfect? We hear a lot about them. The whole idea of a smart contract is, as it says there, it creates efficiency. It removes the need for trust because you are dealing with if-then automated processes by and large. So the arguments are it can eliminate the need for letters of credit because you can put cryptocurrencies into escrow, bonds, other security arrangements, and enforcement costs, transactional costs should come down because of the digitization of processes. But we're here to talk about those problems. So the answer to this is no, they're not perfect, and they will get better and better, which we will touch on shortly. But the second bullet point, 100 errors per 1,000 lines of coding, and that is an issue for smart contracts, and it is an issue that has already caused some pretty significant problems or potential problems around the world. And there's a great one we will talk about shortly. So disputes are going to arise even in this automated smart contract space. And let's go back to the vending machine. Disputes arise there because I can do my part of the transaction, my money, my selection, but the arm in the machine doesn't work, so I don't get the consideration for what I have just paid for. So that, and I might thump the thing, rock it. If I'm at an airport and I've been flying most of the day, I might need to get even grumpier. But disputes are going to arise because things are going to go wrong, and things have already gone wrong. And as I say in that last point, when we're in a dispute situation, a lot of the benefits of this decentralized ledger technology, automation, self-regulation, immutability, i.e. things don't and can't change, actually cause us problems. And there's some of the things we've got to work around as dispute resolution practitioners in this space of this new technology. So I'm going to touch very briefly on a number of issues that have been written about, talked about. We see some of them appearing in the papers. Typically, we see a lot of stuff about hacking and the theft of cryptocurrency, but we're not really talking about that today, although it is one of the issues. So that first issue, 100 errors in 1,000 lines of code. So the coder simply might get the original intentions of the contract, whether it be traditional, legal, or all smart based, wrong. What's going to happen then? And we'll look at what has happened. Is that hackers may interfere or manipulate, and there's some huge examples of that. Will every jurisdiction around the world, whether common law or civil law, look at the principles of offer, acceptance, and consideration and apply them to smart contracts? And where is the world's thinking on that point at the moment? And as I said earlier, is this smart contract code simply a coded transaction, or is it a contract? Is the key to use the encryption? We hear a lot about that with Bitcoin and wallets and keys to open wallets. Is that a signature? Is it a sign of acceptance? Exactly where are the different jurisdictions sitting on that very important point? So as I say, looking at the second point, self-enforcing is great. It eliminates trust, it eliminates payment issues, but it also creates an issue when the parties are in dispute. Self-enforcement of a payment, how do I stop that? If I suddenly go, there's been a misrepresentation here or something has gone wrong. Worse still, payment has been made. How do I claw that back if it's all been done on blockchain and it's immutable? As I say, one of the issues of being on blockchain, smart contracts are becoming securer and securer in the sense of their self-regulation, their immutability, and that's great for confidence and business confidence, which is a large part of why this technology has been built up and promulgated. But how does that help me if I'm the contracting party and I suddenly realize something has gone wrong and I can't stop it? So everyone talks about blockchain and DLT being secure, 100% secure, immutable, and the reality is that's not the case. Yes, it is very secure, but we've all read too many articles of successful hacks, and you can put in what's called a hard fork, which is effectively copying the blockchain and using it to start again. It doesn't overwrite what was there, but you can use it to put a, as it says, hard fork, a break in that particular blockchain. But those breaks, those forks can be used to steal information and corrupt contracts as well. So again, they're issues for dispute. Fake data can be used to trigger if-then clauses. If I have information that's coming in to a smart contract about temperature, and that temperature may trigger a parametric insurance policy payout, then perhaps there's a temptation to rig that data to get a false alert and a false payout. Coding issues, as I have said, hackers manipulating to their own advantage or on behalf of parties if the issues are big enough. And then issues of consent might arise, and this is one that's talked a lot about in sort of legal academic circles about offer and acceptance and consent to a contract, and particularly with the smart contract code where there is little or no written record of what's been done. It's all recorded in the code. Can we say that every party has consented to all of the terms for that contract? So common law jurisdictions worry about the representations of offer, acceptance and consideration. Civil law jurisdictions worry about documentary evidence to support legal enforcement. And they are all grappling with what do we do with these smart contracts. If we get past contract formation, then we're dealing with things like jurisdiction and other legal issues we're going to touch upon shortly. And then we have some things there, the last two bullet points, looking at this sense of arbitration in particular. How does a court or arbitrator interpret a smart contract? If it's exclusively in code, what am I as an arbitrator going to do to understand whether that code represents the interests of the parties or not? And then how do we deal with this idea of gaps in contracts, implied terms, mistakes in contracts? If the contract is on a blockchain utilizing that technology and it's immutable, how do we modify it? If the decision from the arbitration is there's an implied term that the parties intended to go into that code, but it didn't, how does that now get rectified? So, as I say, and that's just really wrapping up. The only one I want to touch on here is this question of oracles, because this is the idea of third-party information coming into the system. And the next slide talks about it a bit more. Blockchain technology doesn't operate in a vacuum. It requires inputs. If you're on a trading platform that uses blockchain, it requires inputs of pricing. If you're dealing with parametric insurance, it requires inputs of the parameters that are being measured, flight delays, temperature. So these are called oracles, blockchain oracles, and it's a reference to the oracles of ancient Greece, who were this trusted intermediary between the spiritual world and the physical world. Here, they are a trusted intermediary between the blockchain technology, the smart contract that needs the data, and effectively the Internet of Things that is providing the data. But they are susceptible to hacking, delays in timing, loss of connectivity at critical times, and that's an important point on one of the arbitrations we're going to look at. So that's an area of concern, or an area of imperfection within this smart contract technology, where things might simply go wrong because the oracle that is performing the third-party service gets it wrong, or one of the nodes, one of the computers that's on the peer-to-peer network gets the information slightly late, but on another computer, payout of the crop insurance has already been triggered by the information that has been received. So those are the sorts of issues where that we are dealing with, and there's a lot of them, but they in many respects boil down to this conflict between self-enforcing, self-regulating, and automation versus, okay, what happens when things go wrong? What happens when human nature steps in? There are variables, etc. And again, the list goes on. The last 3 bullet points are on this fascinating issue of vulnerability in code and the extremes that it can come to. It involves a distributed autonomous organization. Read them up if you like, but that they are typically set up to provide governance to projects or governance to funds. This one was set up, and investors, I can't remember what the project was, but investors were purchasing Ether coins from the platform Ethereum to invest. There was a decision that they would split the fund into a senior fund and a junior fund, but there would be a 48-day delay before funds could be withdrawn by investors if they wanted to do that. But a very smart hacker, coder, found a loophole, and he used it to hack $1.5 billion of coins from the DOA. Fortunately, the hacked funds were also held up for 48 days, so it gave the parties, the investors, 48 days to decide what to do. Many of them, surprisingly, were willing to let the coder, who was not being fraudulent but had simply found a loophole, take the 1.5 billion of Ether coins, because they determined that that was more true to the nature of blockchain and what they were trying to achieve in this decentralized network, and that effectively was going to be a really big payment for a mistake, but they were willing to let that go. However, common sense, or the investors who had really put in the big money, prevailed, and ultimately a hard fork, this break in the blockchain, was agreed, and all of the funds were returned to the investors, effectively collapsing the DAO, it actually should be. But that was the only way that could be seen to prevent payout of the $1.5 billion of Ether coins. So these things, when they go wrong, point is they can go incredibly wrong. And of course, at the moment, there's areas where smart contracts simply are not up to speed, catering for too many variables. Remember, smart contract is really, if you like, a switching mechanism, if then. And you can build in some complexity to that, and you can build in a number of tranches and branches of decision-making tree. But a lot of subtlety and variables, simply there is not the computing power at the moment, as there isn't for subjective tests, and of course, as there isn't for human nature. One of the questions for the future will be, as we get closer and closer to significant computational processing in computing, is how close will we get, or how smart will the smart contracts get? How integrated will they be with AI? What are the complexities and legal issues and concerns around that? Because there will be a push, undoubtedly, for smart contracts to be able to step into an increasingly complex set of decision-making trees and variables to make decisions based upon AI and algorithms on subjective tests, and, dare say it, to challenge human nature and human decision-making. So that's a space to watch for, and these areas will make this somewhat simplistic issues we are dealing with now, enforceability, etc., look, dare I say it, rather simple. And that's actually an important point of what I'm wanting to get across today. So the enforcement of smart contracts, that's the big introduction of where they sit, what can go wrong. So what are the remedies that are available when you want to prevent a payment and it's an online transaction with no intervention, or as I said earlier, reverse the payment that's already been made? Benefits become roadblocks. Where do you go if you want to enforce a smart contract dispute? Will contract law apply? What law will govern it? What evidence is available for the formation of the contract if it's simply all online? Issues of anonymity, which is a big positive or a big draw card into particularly cryptocurrencies, but work on the blockchain in general. It makes it difficult to determine who the parties are, and the decentralized nature of this idea that this network exists everywhere in the world at once, of course, makes jurisdiction and choice of law issues incredibly complicated. And if you can enforce a remedy, who's going to write the code to update, or how do you update a smart contract if it's on the ledger? So as I said, these benefits become roadblocks when there is a dispute. So the jurisdictional legal issues very simply are here: choice of law, or what law applies when you're on a blockchain technology. What is the forum for addressing disputes using novel digital technologies? How are the courts going to approach them? How should arbitrators approach them? How can any agreement reached between the parties be enforced internationally? That's a big plug for arbitration. And what legal system is going to apply to the transactions? Of course, there are a lot of other issues and some very, very big issues. And the one I flagged there is, of course, data protection, which is becoming increasingly an issue in its own right. If there's anybody from Europe, you'll know all about that. GDPR is a very rigorous data protection regime, which a lot of the rest of the world is following or adopting or needing to get up to speed on. And so that is a huge consideration as well in and around the same areas that we are talking about. But let's look at one example, which is the one from the UK and their jurisdiction task force, which has said in simple terms, both types of smart contract, simple code or one reflecting a more traditional contract, are contracts. We see no good reason for treating smart contracts as being different in principle from conventional contracts. So a big statement, a very clear statement in a common law jurisdiction to say, no, we will bring these both into the fold of contract dispute resolution, which is a huge plus in terms of bringing some certainty to some of these issues. Both forms of contracts, smart contracts, are going to be treated as contracts. So if that became the norm for the global legal system, then it means one of the key issues, how to deal with these contracts, will be simplified, and that traditional concepts of contract law will be applied to them. Still lots of hurdles about enforceability and rewriting contracts and implying terms, etc. But it would mean that the issues such as the context of the formation of the contract, implied terms, unconscionable terms, misrepresentation, etc., would all be available to parties who want to dispute a smart contract. So potentially quite a fetter on these ideas of self-regulation, automation, and immutability. Also questions of reasonable good faith negotiation, a force majeure, areas where, of course, smart contracts, the algorithms, the if-then concepts are not sophisticated enough at the moment to make decisions around, are also going to be applied to smart contracts. And now, why arbitration? And we do see a lot of jurisdictions turning to arbitration, and we're going to look specifically at the UK rules in a moment. Why, in my mind, is that parties, particularly to international transactions, can address, should they choose to, all of the jurisdictional issues I just listed, choice of law, etc., in their arbitration agreement in a way that brings certainty to the relationship without complex choice of law issues having to be argued at the outset of any argument about a smart contract. Plus, of course, the New York Convention. for signatory countries. The next one is subject matter expertise. We're going to look at that again on the UK model, and there are other examples of institutions where have set up subject matter experts to run these blockchain and smart technology types of disputes. And of course, confidentiality and anonymity are a big part of blockchain. They're a big part of cryptocurrency. It's a positive and a negative. It has been factored into some of the rules dealing with arbitration. The negative, of course, is all the articles, all the writing, all the stuff we see about ransom payments for cyber attack being paid in cryptocurrencies, etc. And let's not forget, they would like to, but Bitcoin, the biggest user of Bitcoin when it was first put in place was a dark web entity called Silk Road, which was a drug trading purchasing platform where, of course, anonymity was great, and so cryptocurrency fitted well within that. So there are still these competing tensions between confidentiality and anonymity, but the rules seem to be reflecting the fact that the parties may wish to remain anonymous when dealing with these disputes. So the suitability of arbitration. So those are all good points in addition to the flexibility of the process. And we see Silicon Valley, for example, has a specialist list of arbitrators and mediators for this space. Recently, a specialist body has been set up in Poland to deal with blockchain and new technologies. So there are moves to specialize. So one of the questions for today's webinar was general purpose arbitrator or bit of specialist knowledge. I'm normally a generalist, but on this area, I do favor some specialist knowledge just because of the complexities of understanding the technology that you are dealing with. So again, an example, the UK digital dispute rules, which came off the back of that task force analysis, where the UK says crypto assets are property and smart contracts are contracts under English law. So a set of arbitration rules or just digital dispute rules which provide for arbitration and expert determination have been established. They have these key features, which are speed. Unless the parties agree otherwise, you've got to determine it within 30 days of your appointment. So there is no time to waste in this process. It gives the tribunal a lot of power over the digital assets. And importantly, the tribunal has the power to direct any interested party to do things on-chain. And this on-chain, off-chain enforcement is an important part of technology disputes. As the name suggests, on-chain enforcement means you can, if there's an award, an on-chain enforcement would mean that that award is automatically triggered. So the award comes in, the result might be a payment from party A to party B. That on-chain enforcement would be automatic. Off-chain enforcement, we're effectively dealing with traditional means of enforcement, registering awards as judgments, enforcing through the convention, etc. It's an expert panel, so this is a specialist panel appointed by a specialist society to deal with the technical complexities of these disputes. The rules have built into it the potential for automated decisions. I'm not looking today at bot technology for decision making, but it sits there as one of the possibilities of decision making for smart contracts. And the rules have already anticipated legally binding resolutions coming off AI agents or bot decisions. Confidentiality, as I said, and anonymity. So in theory, you can arbitrate against somebody through these rules and you'll never know who that person is. The tribunal will, but the parties won't if that request has been put through the system. The rules don't apply automatically to every dispute. You can't use them unless you are in a contractual relationship, so they will not be used for criminal acts, theft or hacking or anything outside of contractual. And so you are really talking about commercial parties who have agreed on this dispute resolution mechanism in their smart contract and who are willing to cooperate. Enforcement, as I say, these rules provide for on-chain determination, meaning that awards can be instantaneously actioned. Also, the arbitrators can implement decisions directly on-chain through the use of a private key. So this question of, well, who would rewrite the contract If that is required as part of the arbitration award, the answer is the tribunal. But there are questions, as I've said there, about how they would access that, because they will need to get private keys, presumably from the parties. If there is no on-chain enforcement, then fall back on the New York Convention. But one flag for that is this requirement in the convention, because remember, it's a few decades old now, of requiring proof of the original agreement or a duly certified copy. Query, difficult if that's in code only, but I'm sure we will find a way around that. No rights of appeal. Not a lot of precedent value, although there is the opportunity, if the tribunal considers there is sufficient interest and the parties don't veto it, is to anonymize any decision or award and provide it for publication. So we can get some ongoing benefits out of this system. So DLTs and the use of arbitration, two ways where blockchain comes in. We've just been looking at one, which is how you bring blockchain technology into arbitration. The second is actually using the blockchain technology itself in the arbitration process. So this is switching it around now and saying, well, okay, how can this decentralized secure mechanism be used in arbitration? And these are some of the ways. And it comes back to that point I was making earlier about the importance of data protection. Not unheard of for arbitration information and data to be hacked. And as a tribunal member, it's a constant source of concern that, you know, my computer system will get hacked and someone would access all the electronic bundles that I work from on any of these arbitrations. So a very real issue. So blockchain has been looked at to assist with the encryptability of data. And there's a great example of the Baidu search engine, which is based in China, which has set up a blockchain solution for arbitration to ensure electronic evidence is trustworthy, accurate, and safe from tampering. And it also allows secure storage and transmission of data. So not a negative of blockchain and smart contracts, but a positive vis-a-vis arbitration in terms of assisting us with encryptability, security, particularly in light of these ever-increasing data protection concerns around the world. And then blockchain can be used for automatic referral. We're going to look at those in a second. Cryptocurrencies used for security of cost or escrow issues. So again, we get a lot more artificial trust in the sense of automation and self-regulation into things like security for cost payments, escrow issues. So all areas where blockchain can support us in our arbitration work. And then briefly, I want to go through some of the issues around online dispute resolution, because as a lot of what I've been talking about is arbitration in the more traditional sense, but of course we can bring and protect, perhaps you know, there's a lot of incentive to bring the arbitration itself into the blockchain, and parties are looking at that around and working on that around the world. And here's some examples. Sagewise, they did a big fundraising in about 2017. The company still exists and they still say that they are working on this, but I'm not sure how far they have got it. It's not an arbitration solution itself. It's a technology which you would use to integrate into your smart contract. And it's a set of parameters about contract execution and disputes and how to escalate a dispute into a dispute resolution process, including both mediation and arbitration online. Another one that is there is OpenBazaar, which is a market, it's a trading, sale of goods and services platform using a variety of currencies, and it provides for its own online arbitration dispute mechanism in much the same way that eBay and Amazon and others have been huge successful users of ODR in their disputes. And this is really an expansion of their learnings and all of that technology into a broader space and encompassing arbitration particularly as well, and moving into more complicated transactions than simply that buy-sell transaction of goods as we develop the breadth of smart contracts. So not entirely self-executing, because if the parties select, there is a notary who verifies the contract and its execution and becomes an arbitrator if there is a dispute. The other big one is crowdsourcing, which effectively, as I've said, is determination by the mob, and this is gaining a lot of traction, and certainly there are a number of players working in this space, and that is where, and again, all online typically, you buy tokens to a platform that entitles you to register yourself as a juror. You vote, putting up your cryptocurrency. You lose it if you're on the losing side. You win it if you're on the winning side of the mob, the group decision. Built around game theory and some complexity developed by a man called Schilling, which I won't go into. But the process is designed to encourage jurors to be as informed and honest in their decision making as possible, because they have at risk their tokens if they are on the losing side. And there are a number of examples. One I looked at in depth recently was this Kleros. I reference back to ancient Greek times as well. It's an online court built on the Ethereum platform. Again, jurors, you buy tokens, you lose them. If you are on the losing side, you pick up the tokens effectively of the losing jurors if you are on the winning side. Last point is the really critical point. Very recently, a court in Mexico held that a decision of the Kleros jurors in a landlord-tenant dispute was enforceable. So a really important point in the evolution of these online crowdsourcing determination bodies. Aragon's another one, very similar to Kleros, 3 layers of dispute resolution. You can appeal, and you just post more money, post a greater bond and tokens, and there is the Supreme Court made up of all the jurors with the highest success rate. So obviously those who are on the winning side the most frequently. So quite a sophisticated, you might say, online crowdsourced majority decision dispute resolution process. And jur, which is there to read, again, similar in the way that it works to Kleros and Aragon, can be open or closed, meaning any token holder can jump on, or only those who have been vetted can. And the website says what it is there to provide. So a lot of work, a lot of activity in this space. So, yeah. Where does that fit in? Well, I think we'll see an increasing use of ODR clauses in smart contracts. And either you can build into your smart contract a more traditional dispute resolution clause, or you can make that dispute resolution clause ODR based. So either party can push a button virtually to freeze the execution of a contract. As it says here, and if you do any reading on this topic, there's concerns about misappropriation of that ability, having very strict timelines on it, having to post security if you are going to try and freeze execution of the contract. Again, all things perhaps necessary to make sure that parties aren't abusing the system and fettering away at the benefits of technology and efficiency and the self-regulating ideals of this decentralized ledger technology. Now, a couple of slides on some stuff that's actually happening at the moment, and of course, as always with arbitration, unless it's investor state, it's really difficult to get a feel commercially on what's going. So this is pieced together from press reports and interviews and things, but Binance seems to be under a bit of attack. If you know it, it's the massive trading platform built in China, I think in 2017. It's come to incredible prominence very quickly, outstripped some of the other trading platforms around the world. It is literally everywhere in the world. And I think I read trades something like $100 billion a day are traded on this platform. So massive. There is talk that there is an ICC proceeding underway in Switzerland, because that's where the terms of use had their arbitration focused until recently. The allegation is that the platform's automated liquidation system cut an investor off, forced the sale of crypto, and he lost, he says, significant amounts of money. Not that different in theory, this liquidation process, from a more hard copy traditional trading platform. They all have these automatic cutoffs and forced sales, and I've done more traditional cases on them before. So it's an area that goes hand in hand with trading platforms. It's not specific to trading technologies or trading on a blockchain platform. But the last point is the important one. Supposedly 45 of the Binance entities have been joined to it, and that's directly back into this question of anonymity and who are the respondent parties. The second one, there's also been a bit of press about, and that's what started as a group of 6 investors who got litigation funding out of Europe for $5 million to sue over an outage on a particular day. 19th of May 2021, this year, the Binance trading platform was down. It happened to coincide with a very violent swing, and in this instance, drop in Bitcoin. And the claimants are saying that they lost a significant amount of money on that day when the platform was down. Again, not much publicly, but there has been some commentary from the litigation funder out of Europe. That's Mr. David Kay, you see there. It looks like a number of traders have jumped on, and they might be up at around about $100 million of alleged losses for that drop in trading on that day. So some of the aspects look like every other piece of arbitration. Terms of use, so the terms of use now refer the seat to Hong Kong through the AKIAC arbitration process. So that's been changed from Europe on the first one. Large number of corporate vehicles. There is at least one, it looks like, registered in Hong Kong. The prospective claimants are talking about a class action, but that might be prevented, the press reports are saying, by the terms of use. So looks a fair bit like other issues that we deal with in international arbitration. Big challenges coming in, identifying the proper parties. Binance has been famous for a very opaque global structure and for being everywhere. So who are the parties to the arbitration? What is the legal status of the actual trading platform? Who owns it? If it's a trading platform that created the losses, what entity is that? Substantive legal and liability issues. You've got everything coming into one legal regime, which is Hong Kong, but applying it to an international and decentralized set of services that are performed, no doubt, in Hong Kong, but everywhere else in the world. So is one legal regime the right approach to apply to these types of issues? And then if you are looking at that particular legal regime, as we are Hong Kong, what are the questions of illegality? Hong Kong does not allow unlicensed derivatives trading in its territory. So is there a question of illegality of this within the Hong Kong regime? And ultimately questions of arbitrability under Hong Kong law. So very big issues, not uncommon issues, but applying them to this type of decentralized position, they become quite complicated and novel issues to work through. And then enforcement of crypto assets, that one's probably getting a little bit easier with the position a lot of jurisdictions are taking around the globe on crypto assets being property. And then a really big one, on-chain enforcement of the award. Is that going to be possible? What would that look like? So again, particular to the smart contracts, will that be a function of the order sought? Will it be a function of a part of the arbitration? Finishing off, very conscious of time, but I'm happy to keep going. I'll just finish this off in a minute, then take questions if there are any. Crypto assets as property seems to be getting clearer and clearer. Very proud to say that one of the leading decisions around the world on an informed reasoned judgment basis is from New Zealand, which says yes, they are. There's some interim decisions come out of the UK that support that, but they typically are around the freezing of assets and interim orders. So this is one of the few that's been well considered around the world. And it also looks at this other important point, going back to data protection, of digital assets versus pure information. And for me, there will be some big debates very soon moving forward of when AI created algorithms, etc., go from pure information into digital assets and therefore become property. And realistically, we're probably there already. So really important decision, very useful. It used Lord Wilberforce's opinion in a very long-standing, well-considered decision of the House of Lords. It's the same decision that the courts in Singapore have used to look at this issue of when assets are property, but they didn't decide they didn't need to decide it. The New Zealand High Court did and said, here, the 4 pillars have been met, so this is property. It also said there is a trust, because that was the second question, and on the basis of the facts of this case said, yes, there was a trust. So taking out of this, crypto assets can be property, and crypto assets can give rise to a trust. So very important jurisdictional and legal issues, which I tend to think the majority of jurisdictions around the world will follow. There's a lot of inherent logic in what's being looked at here, and I would be surprised if common or civil jurisdictions took a different view unless legislated against on property arguments. The conclusion really is this. The law has, throughout many decades, centuries, dealt with novel issues. For me, what we are dealing with here on blockchain, smart contracts, cryptocurrencies is less about are these things pushing the boundaries, or are they outstripping the law and the law's ability to regulate, or are they outstripping our comfort level around understanding these technologies, applying these technologies, and working with these technologies as lawyers, as arbitrators, as mediators? For me, very much it's the latter. The law, as we are already seeing, will adapt to these processes. It will think through the issues. We will get decisions. We will get good arbitrated cases and awards that come out that deal with all of these things. Yes, we are still finding our way, and yes, it will take some time. But the more important thing for me coming out of this presentation is that the rate of change is going to be exponential from now on, and this feeling of uncomfort and this feeling of having to adapt is not going to be an every decade thing. It's going to be 2 or 3 times a year. We will be trying to apply these new learnings and new possibilities into our legal paradigm, and that's where the rub and that's where the challenge is going to be for us. And that's really what's come out of it for me, and looking at the research and looking at this paper. So that's where I am. Some stuff has come up. Could the organizer please share the PowerPoint? Yes, that's going to be put up in a read-only mode, I think, on the website tomorrow. What are the legal challenges of NFTs? So NFTs are non-fungible tokens. For everyone who doesn't know, those are digital assets that are all the rave at the moment. So a digital painting, non-fungible means they're not transferable dollar for dollar like cryptocurrency. It's not easily traded. So non-fungible is a complicated way of saying that. They are a form of smart contract. I think they fit reasonably neatly within the smart contract as property and the enforceability. So I see the enforceability stuff we've been talking about today as working with NFTs or non-fungible tokens as well. I don't see an issue with that. A quirk if the NFT is severed and owned by several people. But again, falling back on legal principles, that's a question of getting all the parties to the arbitration or the court case or the dispute as identified as possible. So there will be some anonymity issues there, etc. But again, workable through the mechanisms we've been talking about. What kind of property specifically is cryptocurrency? That's a really good question. Perhaps could you amplify that, Andrew? Are you talking about, is it own and personam? Is it exactly what are you talking about there, so we can perhaps chat about that?
Is there any other question? Well, thank you, Paul. Thank you for your very wonderful sharing and advice. As for the PowerPoint, yes, we will upload all the PowerPoints to the Hong Kong Institute of Arbitrator website for everyone's reference. Okay, so and I think that concludes today's seminar. And before I conclude, I would like to highlight that we have sent our CPD evaluation form to all the audience. So please remember to send it back to us after this seminar. And with that, thank you very much, Paul, and thank you everyone for attending today's seminar.
Yes, thank you, everybody.
Thank you. Bye-bye. That's all for now. Bye-bye.
Bye.